Hello, my name is Michael Comorn of Comorn Law, and I wanted to talk to you today a little bit about the Michigan Medical Marijuana Act. This is a law that is designed to protect patients and caregivers. It's often criticized and misinterpreted, and I want to give you a few clear things that you can understand and use if you're a patient and caregiver to try to have positive police encounters as a patient and caregiver. First and foremost, try not to have police encounters. In other words, when you're acting as a patient or a caregiver, don't rely upon or think that you're going to need to rely upon your card. Go about your caregiver and patient business as if it's no one else's business. That's number one. Number two, as a patient who possesses a card, they are allowed to possess up to 2.5 ounces of usable marijuana. And even though it's not required in the law, I would suggest that you keep it in a place that is not immediately present if you're driving with it in the vehicle, and certainly not something that you would have visible if you're carrying it on your person. For a patient or a caregiver, usually best to leave it at home and travel with it only when necessary. The caregivers are oftentimes in the firing line as well, and they shouldn't be, but some of the things that they can do to protect themselves from those negative police encounters are, one, the enclosed lock facility requirement of how you keep your plants should be considered in a very serious manner. Even though I don't necessarily agree with the law enforcement interpretation of this, I'm suggesting that you keep this facility in a way that nobody else has access to it other than the caregiver. Secondly, caregivers are allowed to possess 2.5 ounces of usable marijuana per each patient that they are caregiving for, and that number maximum will be not more than 5 patients. So the most amount of marijuana that a caregiver could be possessing is not more than 15 ounces of usable marijuana, and I'm talking about flower. The weights and volume limitations for marijuana-infused products is different weights, which we can talk about on another day. But most importantly, and the thing that patients and caregivers are oftentimes confused about, is that the delivery and transferring or selling of marijuana can happen in only one direction in order for the immunity to be applicable. That means that a caregiver can only sell, transfer, deliver marijuana to their specific patient to who is enumerated on that caregiver's card. And this would be not more than 5 patients in total. On the other hand, and just to make things very, very clear, the patient who may be on the back of the card of the caregiver can acquire cannabis from that caregiver or anybody else for that matter, even from unlawful or illegal places, because the right of a patient to possess marijuana is a right that exists within the law, and there's no limitations to that. In short, the Michigan Medical Marijuana Act is intended to protect patients and caregivers for the medical use of marijuana. It's a very broadly written definition within the Michigan Medical Marijuana Act, and that's its intention. And just to expand a little bit on the requirements for a caregiver to be protected under the Michigan Medical Marijuana Act, there's a definition which is known as the enclosed lock facility. The statute as it reads under the Michigan Medical Marijuana Act would seem to suggest more than one person would be allowed in that facility. The definition of medical use of marijuana would seem to suggest that a person who would be in the facility taking care of the plants would be something they would be protected for. The problem that we have is that the immunity determination from arrest, not a prosecution, that takes place in court, but the immunity that a patient or caregiver may have from arrest takes place in the moment as the observation or determination of compliance is taking place, which is why I give this advice. There is no court that will intervene and tell at the time whether the police's interpretation of what an enclosed lock facility really means. It's going to be the police's decision at the time. The interpretation that they use is that if anybody else has access to the plants, that is a violation. I don't say this because I see it as the interpretation of the law. I say it because I read it in police reports. It's often hard to even understand how that interpretation can be made when the actual language in the act clearly articulates at least 2 individuals would have access to the enclosed lock facility. There's some confusion about whether a patient is allowed into the caregiver's room. It's difficult to even consider how could that not be allowed. caregivers caregiving for that particular patient. I'm telling you, despite my indifference to this interpretation and disagreement to it, the patient of the caregiver should not enter the enclosed lock facility where that patient's marijuana plants are being grown, because the law enforcement community is interpreting that to mean that you are not immune, those plants will be taken down, your immunity will be vitiated, and then you're subject to all the forfeiture penalties that exist under the Public Health Code. So my advice is, even though I disagree, take steps to be aware of these things that I'm telling you and avoid circumstances that are going to show evidence or appear that anyone other than the caregiver who's taking care of those plants is the only one who has access to the room where the plants are being grown. In other words, no patients at any time of that caregiver or anybody else should be entering the room. If you follow that advice, you should have more positive police encounters. To stay out of trouble, follow those tips that I've laid forth today, and remember to have your card on you at all times, and most importantly, try not to have police encounters. If you do, however, remember to call Comorn Law, 1-800-656-3557, and we'll take on your fight for you.